Ladies and gentlemen, on behalf of Forrester, Boughman, and Lefkowitz and Lowe, I want to thank you for attending our webinar today. This is the first in our healthcare law series. Today's topic is physician employment contracts. Our attorneys presenting today are Eric Boughman, Brian Evander, and Mike Lowe. And with that, I turn it over to you, Eric. Take it away, sir.
All right, thank you, Tony. Good afternoon, everybody. I am very excited to be joined by Michael and Brian to talk about physician employment agreements. We have a lot of material. There's some handouts that are made available through the webinar app. And if you have any questions throughout the presentation, please shoot them to us, or feel free after the webinar, if you have a question, shoot it out to us, and we'll do our best to respond and address it. And with that, everybody's introduced, and we'll move along. So our agenda today, we'll talk about generally just an overview of the contract structure and some of the issues to look at as you get ready to negotiate an agreement. Some of that will involve as well the relative bargaining power. So if you're a new physician, new employee of some sort, and you're negotiating with a large entity, chances are your negotiating power is going to be substantially different than if you have an established practice and you're negotiating with another small group. We'll go through some of the basic elements of an agreement and try and call out some of the more important provisions, especially those to be aware of. You know, there's really two elements to this that I see, and Mike and Brian will add their thoughts as we go through. But you know, one is what types of things can be negotiated, and another is just, even if it can't be negotiated, what do you need to be aware of? And with that, I think of what I tell clients is, think of what this is going to look like if things go south or at the time you're leaving. And for instance, if you have a certain notice requirement, you know, understand what that notice requirement is, understand the provisions under which you have a right to terminate an agreement with or without cause. And even if you're not negotiating those provisions, make sure you're complying with them. And we'll talk about some, like I said, some of the important provisions and considerations, and choosing legal counsel, some key negotiating points, and we'll take questions throughout. And if we have a few minutes at the end, we'll also take some questions. So, Brian or Mike, do you want to kick us off with a little intro into the agreements themselves?
Sure, I can get started real quickly, Eric. This is Michael Lowe. So one of the first things I'll always ask when you talk to a client is, when you're looking at an agreement, if you're a physician individual client, what's the first thing you look at? And they'll always say the compensation. And we like to tell them, well, the first things we look at are the termination provisions, the restrictive covenants, primarily what everyone thinks of as a non-compete, and then the tail insurance. And those are very, very specific considerations that have to be dealt with up front in the agreement so they don't bite you on the backside, shall we say, if you ever disengage. It's also important for an employer because sometimes things don't work out and no physician ever stays on their same contract for their entire career. I think we're going to focus on all three of those today. But from a healthcare standpoint, that's what we do here as a firm, and being a board certified healthcare lawyer, we're seeing a lot of trends changing, a lot of consolidation still going on in the industry. So as Eric said, you have to be very conscious of who you're negotiating with and what's negotiable. If it's a big system, if it's a multi-specialty practice, if it's a small practice, a hospital, those points can change from employer to employer, and if you're the employer, they can change with regard to what you're negotiating with the employee, and we're going to hit on those today. Brian?
Yeah, and going through the basic elements of the agreement, there are things in there specific to health law that if you've negotiated other contracts may not immediately jump out at you. Like Eric said, you're not negotiating for what you know today, you're negotiating so that you know how things will be handled 5 years from now. If you're hiring a physician and Right now, they're not excluded from Medicare or Medicaid. You want to make sure that in the agreement, you've contemplated what happens if this physician is excluded. How will that be handled in the future, and is it grounds to end the relationship for cause?
So different types of agreements we've listed there, and obviously today we're going to talk about the physician employment agreements. And what's important to one person may not be exactly what's important to somebody else. Like Mike said, most people usually look at the compensation, but there are some other important points that we're going to try and pull out here. Defined terms is one. Whenever you're reading an agreement, oftentimes they'll be underlined or bold. If you see a term, don't assume you know what it means when you read a contract. Sometimes you'll see a specific term, and it's either a term of art specific to the practice, or oftentimes you will have, you may have a definition section in the agreement, or you will have terms that are used throughout the agreement to have a specific definition or connotation.
Eric, can I back up for 1
Absolutely.
minute? I missed something here, and if we go back to slide, the one on types of agreements, just a couple key points, and this applies to both the employer and the employee. I think, and putting this together, we did a great job in terms of the types of agreements. And the last two are particularly, well, actually the last three are particularly important for both sides. If it's an ownership agreement, typically the way that our firm and the attorneys that do this, including the three of us, like to do it is there's a separate ownership agreement. They're cross-referenced and they're incorporated in terms of if one ends, like if you have a shareholder or an operating agreement, if it's an LLC, then the other should terminate with it. Eric and Brian have a lot of experience in litigating those things when someone leaves a group and then you have to have a buyout. How does the buyout work? Is somebody still entitled to certain ownership rights even though they're no longer an employee, and vice versa? Physician recruitment agreements are particularly complex. They invoke a lot of Stark and anti-kickback statute, and also Florida Patient Self-Referral Act and Florida Patient Brokering Act requirements. If you're doing a recruitment agreement, and typically those involve a large outside third party like a hospital or a system saying, we're going to help fund a group recruit a physician in when they can't necessarily afford, or it's not cost effective to put the whole capital outlay out up front. But there are very technical requirements, and you can run afoul of those very quickly. So you need competent counsel and healthcare counsel to look at those. Just as an example, we've handled a number of these where there's been a non-compete involved with a Stark Law issue, and whether the non-compete's enforceable or not enforceable based on the Stark Law and the recruitment agreement. Also, if you're a physician, a lot of times if you have a recruitment agreement and you have a non-compete, you have to leave the area. And then the question is, who's on the hook for repaying the hospital bill? They can't just forgive the bill. You get into kickback issues. And then finally, a collaborative or supervisory agreement. This is becoming very prevalent on a number of levels. And regardless of whether you're the employer or the employee, you have to understand the state and local laws, and also the federal laws for direct supervision of ancillary or providers like nurse practitioners or PAs, and what they can do, and also what the liability and the regulatory requirements are. Sorry, just want to get those in there. Those are key factors in those types of arrangements.
No, it's great points, Mike. Thank you for calling those out. So initial due diligence, when you are, this is going into your negotiations and as you're preparing to review an agreement or put an agreement together. Now, oftentimes, again, depending on the bargaining position, a group or an employer will have an agreement already, and they'll oftentimes hand it or send it out or hand it off as though this is the form agreement, this is what everybody signs, and they'll just give it to you. Don't assume that those agreements are not negotiable. There are still terms in there that you want to look at and you want to be careful of. If you're in a position where you have a little more bargaining power, or you're dealing with a smaller group, you may actually have some negotiations. Oftentimes the monetary, generally outlined monetary terms are in there. There may be some other key points with respect to term of the agreement, and those are points that may be determined prior to the actual putting pen to paper and drafting an agreement. But when you're doing your due diligence here on the slide, Brian, anything you want to call out in particular on due diligence?
I think it's important to know on the hiring end exactly what certifications, what licenses, and beyond the basics like those, you want to have something in the agreement that requires a disclosure. If you're hiring a doctor and you want to know whether or not just whether this doctor has had discipline, but if this doctor has had probable cause found by a governing body such as the Florida Department of Health or the Agency for Healthcare Administration. You want to have something in there so that there is an affirmative duty for the other party to disclose those sort of things, because they're not always things you're going to be able to find online or from a source other than the other party themselves.
Adding one thing to that, one of the things that the doctor can do that often you can't if you're a group practice or non-hospital is request their data bank report, their federal data bank. The Healthcare Integrity Data Bank and the National Practitioner Data Bank merged their functions about 2 years ago. So if you have the physician provide, they can self-query and provide that. You get a list of all their malpractice history, at least of what's reported. Exclusions, very key point that Brian brought up before, because if you contract with an excluded individual, you can be sanctioned under federal law and possibly also excluded from participation in federal healthcare beneficiary programs like Medicare and Medicaid. You can also get any credentialing issues if they've had a medical staff issue at a facility, criminal background. So it's good to ask for it. If you're a hospital or surgical center, you can request those because you're a credentialing entity. But great point on looking into the due diligence. A lot of employers forget that and just take at face value what people give them. And sometimes folks forget to tell you everything, as Eric and Brian will tell you. And that's when we end up litigating.
You don't say. So some of the issues that we just we heard about, obviously licensure issues, background. You won't often in references now. Everybody's afraid to give you any more information and other than validate the fact that somebody may have attended somewhere or been employed somewhere, but make sure you're checking the issues as far as background and know who you're hiring. By the same token, if you're going into a new employment situation, do your due diligence about the folks you're going to meet with. And a good source of information can oftentimes be other younger, newer physicians or employees, their spouses, folks who used to work there. There's ways to find out other information. People who were previously employed by an employer can be excellent sources of information, but you also have to take it with a grain of salt, sometimes understanding that if they were previously employed, they may have an axe to grind.
Brian, Eric, I know we do a lot of cases. We're looking on people if we're going to depose them. We have background check entities we like. Are there any preferred methods you like that won't expose someone to liability in, say, a due diligence situation like this?
Yeah, I like to use a private investigator, and there's two in particular that I use. Sometimes that information needs to stay private, but it can be very valuable. If anybody has any questions about that, reach out offline, and I'll be happy to make a referral. And Ryan, anything else?
No.
Now there's so many public database sources online, you can get a lot of that information, but I just like to go through a third party. Contracting parties, I think Mike, you hit on that a little bit earlier. If anything to add?
Yeah, just the only thing with the difference between a hospital and there's two big differences with hospital and group practice type or independent group practice. One is going to be the type of compensation. Hospitals have moved, systems in general have moved more towards a quality based. They're looking at the MIPS, the MACRA type, ACO type arrangements. So it's important if you're a physician contracting with them that you understand that and you understand exactly what your compensation structure means. If they say it's guaranteed for X amount of years, what is it? Like Eric said, what are we looking at 5 years from now? It looks great up front, and you get this nice guaranteed salary and maybe a performance bonus over the first few years. But what happens when it says, hey, we're going to renew it 5 years, and you don't like the comp structure? Are you now non-competed out? Are you going to have to buy your own tail? The second thing with hospitals in terms of that is who actually governs the group? Who is going to have the say in hiring and firing of employees, third-party payers? Do you have a voice in that as a pure employee? A lot of groups, like say locally, Orlando Health Medical Group or Florida Hospital Medical Group, are fully owned for-profit subsidiaries of a nonprofit organization. They have their own boards, their own governance, their own executive directors, but you have to find out if you have a voice in that. A lot of doctors go to work for hospitals, don't understand that they're giving up their autonomy and they don't get to make decisions as easily with regard to the running of the business. So those are two very key things in a hospital agreement, different than a private practice.
As far as professional duties as they're contemplated in a physician employment agreement, location, for example, where the physician is being contemplated to practice within the entity has more implications than you'd think. We'll get into this a little later, but restrictive covenants such as non-competes can be tailored to or enforced by the courts based around which locations within the entity were actually contemplated in the agreement and used by the doctor. If an entity has 5 offices spread out over 2 counties and the doctor only works at one of those offices in one of those counties, it's going to be harder to enforce a restrictive covenant to keep the doctor from competing, say, within 5 miles of any of those locations or within both of those counties if the doctor and his employment, as is contemplated by the agreement and an execution, is only focused in one office and in one county.
And another point on there with the offices is better to define in the agreement whether the offices are as they are contemplated when you sign the agreement or whether that can change later. And I've seen the situation, I'm sure you guys have it with a non-compete where there might be 2 or 3 offices and then the doctors or somebody's leaving and there's more offices, or the offices change locations. So you'll see, okay, you're not going to compete within 10 miles of the office and the office is in one location. Here we're in Central Florida. So if that office is in downtown Orlando and suddenly that office moves out to the north side of town in Lake Mary, what does that non-compete restriction apply to? Is it Lake Mary or is it Orlando? So that's an opportunity to spell that out clearly at the front side of the agreement rather than trying to figure it out on the back side.
Next on the moonlighting, basically how does the agreement define the scope of employment? Is this exclusive? Are you asking for the full and complete commitment from this person of professional service exclusive to that entity, or are they allowed to have other employment or other work as well? And then you have to determine whether the malpractice insurance is going to cover the doctor as a whole or only the doctor for the services they provide at the entity.
If you're an employer in that situation, you would want to have your agreement state that if you're allowing them to moonlight, as Brian said, you want it to have specifically state what they can do, that it won't interfere with the performance of their duties. It's not just whether that you're letting them have a carve out to non-compete, but it's not going to interfere with the performance of their professional duties or their scheduled work times. But as Brian said, the malpractice insurance, they should carry their own if you're the employer. If you're an employee, you should definitely have your own. A lot of carriers won't allow for that. We do med-mal defense here. We do coverage work. Brian and I do a lot of med-mal defense. When we need personal counsel or coverage work, we call Eric. And we see this a lot where people forget to tell their carrier, oh, I'm going to be moonlighting at XYZ, and they think they're covered under their employers. The employer thinks they're covered under it, and they're not. And then something happens, knock on wood, and you're bare for your defense. And that's not a good thing. Even though we do asset protection, we like to do it proactively, not reactively. So,
good point. It's better to have to defend with the insurance in place and have the insurance pay for the defense.
Absolutely.
Regarding attendance of staff meetings, I would tie that in with general obligations outside of the 9 to 5 office. there's an understanding or an intended understanding that this physician is going to be on call or perform rounds at a certain hospital or provide some sort of, give a CME of some sort every year or two for marketing purposes. If there's any sort of obligation like that or expectation, you want it to be in the agreement so there's no misunderstanding between the parties as to what the physician's obligations will include outside of the typical office duties.
Good points. I want to hit, make sure we hit some of the other stuff. Anything else that you'd call out specifically on that one, Mike or Brian? Okay.
No.
I think we hit that well.
One thing. Compliance with laws and policies and procedures. Laws are one thing, but if your employer has a policy and procedures, if you're the employee, ask to read them before you sign the agreement. I always like to use this example. It's a bit tongue in cheek. I think I got a Gator fan in here, in Brian. I played at Navy, so I just kind of stay out of the FSU-UF rivalry. But let's just assume Eric's an FSU guy, and he says, hey, to come to work here every Friday, you got to wear garnet and gold. Brian might have a material difference with that thinking. He might like blue and orange. And I use that as a very facetious, tongue-in-cheek example, but particularly with doctors, if you got to read them, and particularly if they're clinical, you got to understand that you're going to fit within that culture of how they practice whatever medical specialty you're in. Read them. It's caveat emptor, buyer beware. Judges don't like to hear that, oh, I didn't read it beforehand and I'm a doctor, because then they're going to ask you how long you went to school to become a doctor and can you read. So
yeah, that's a great point. And with that, with the rules and policies, sometimes you'll see where they're expressly incorporated into the agreement. So you sign an agreement that says you agree to comply with all policies and rules, and the agreement can't be amended except by a written document between the parties, but the policies and rules can be amended on much more lax basis. So understand, what those, like Mike said, that's a great point. You'll figure out what you're agreeing to ahead of time and also understand how they can be changed.
And one of the most common places you'll see the bylaws, policies, rules, anything like that incorporated is going to be in grounds for termination. Any good physician agreement is going to have a ground for termination if there's a failure to comply with the policies and procedures of the entity.
that's an excellent point. We actually went through this for a client recently. We'll never identify who the client is or the specifics, but we actually wrote the agreement. It was written pretty tightly. It was from a template I've used for years. We wrote it tight, and it was obvious. We wrote it for the employer. It was obvious the employee was not following those policies and procedures. And instead of coming to us and saying, hey, how do I terminate under this? The employer said, you're terminated with X amount without cause days, and then basically realized the employee wasn't going to follow the policies and procedures and tried to bump that up, and it wasn't covered in the contract as a for cause, and it ended up in a potential lawsuit. Brian and Eric got involved, got it negotiated and settled, but the point of being is, if you're going to put those in there, follow them, number one. And two, if you're going to pay good money to have competent counsel write these, call your counsel before you terminate on a policies and procedures issue, okay? Because otherwise you can create yourself quite a mess. And you don't want to spend money you don't need to spend. So,
great points. And we'll get into in a few minutes on the differences between, a contract terminating on its own terms and for cause and termination that's not for cause. Representations and requirements by the physician. Every contract is going to have representations and warranties. People sort of gloss over a lot of this, but this is important. This is the stuff that Mike mentioned earlier and Brian touched on as well. Do your due diligence, find out about the person that you're hiring. And not only is an employer going to find out who they're hiring, but then they're going to want that person to make promises in the agreement that the representations that have been made are truthful, and you can be terminated and sued for breach of contract if you make any representations that are not true. And some of the most common ones are listed here. And Mike or Brian, if you have anything to add to that.
Well, we include these in ours. And then, you look at the backside. If you talk to one of our transactional lawyers here, they'll tell you these are pretty common reps and warranties in any transaction. If you talk to one of our litigators like Eric or Brian, and I litigate from time to time, but these guys know this stuff, if you have a breach of a rep and warranty, you can go back and unwind the whole contract. And if you're the employer, or more importantly, the employee, you can be on the hook for a lot of things like compensation that was paid in reliance upon this that now can't be collected. Say if you weren't board certified, or your DEA registration, or wasn't good, or your malpractice coverage wasn't there, and then a carrier rides in and says, we're not going to pay for, the care and treatment this doctor rendered because they're not board certified. And now as the employee, you're getting sued, or your employer, you might be getting sued for an overpayment and a reduction or a recoupment of money. So these aren't just words on paper. They have real legal effect. Eric's litigated this in a number of settings, not just employment agreements and reps and warranties, but they are enforced, Eric. I mean, if you can touch upon that a little, it gets very stressful in those situations.
Sure. If you can, I mean, the best way to unwind an agreement is if you could find out that the person who signed it made a misrepresentation. You have not only common law fraud claims, but you look to the reps and warranties. Now, two other points that are important on the reps and warranties, and what you can do if you are, especially if you're the party who's signing as the employee or as a physician signing this. One is take a look at the bottom couple points here. You're going to make a representation and warrant that there's no pending malpractice claims, there's no pending investigations. Well, you may not know. There may be a pending claim out there, but you haven't gotten notice of it. So if you sign a rep that says there's no pending claims, and then you go and you get hired, and it turns out there was a claim pending, you just didn't know about it, you've now violated that rep. So you can change it, and you can make that change and make it that, based on your knowledge that there's no pending claims.
And building on that, we usually put in our agreements, we see them in others, that it says you have an ongoing duty to supplement or update this information. Right.
And then another way you can protect yourself in signing these is you can limit these sometimes. I've seen them actually limited down to a year, so that your reps and warranties, that you shorten essentially the statute of limitations on when somebody can bring a claim. So you make reps and warranties about your status, and several years later an issue arises, and it's really where the employer is really making a mountain out of a molehill, you think, because it's 7 years later and they're bringing up some issue. Well, you made this representation back here and it means nothing. So you can actually limit those sometimes. What's the time that you can actually bring that claim for a violation of a rep or warranty? All right, so some of the things you want to look for when you're signing, and you'd like the employer to assure in the agreement, and always keep in mind that if it's not in the agreement, it really doesn't exist. So if something is important to you, make sure you get it in the agreement. And you just want to, in general, make sure that you've got the working conditions that are going to help you be successful, and that the working conditions are consistent with what the employer is representing to you. And if something is particularly important with respect to your work environment, management issues, again, make sure you have it written in the agreement.
Point 5 there is a great one about allowing, if you're the employed physician, allowing you to review all claims submitted for payment. A lot of times the agreement will say that you give them the right to act as your attorney. In fact, the employer to submit, you'll sign all documents necessary to submit claims and be paid on them. You need to review your own claims. Billers, coders aren't always correct. Sometimes, I know it's hard to believe, but folks will commit fraud without you knowing it. They'll use your license number, your billing numbers, your NPI. So you should have the opportunity. I'm not saying you have to review every one, but you should take a sampling once in a while and just see what's being put out. Make sure that what you're entering in a global fee ticket or a claims form is translating and transmitting on to what's being built. Because ultimately, as an individual physician, whether your employer submits a claim or not, you're still liable if there's a problem with third-party payer like Medicare or private insurance.
Some additional points that you may want to consider as the employee, the representations you want from your employer. If you have a particular practice that requires a certain level of support or a certain credentialed support, make sure you have that you come to an agreement and have that written into the agreement. So later you're not in a situation you find yourself, well, you're not able to succeed because you're not getting, you don't have the required staff or the required equipment in order to facilitate your success.
Especially if you're a high-end medical specialty, yeah, make sure that's there up front. Employers don't like to fund things after the fact when they haven't planned for it.
Compensation. Mike said this was the first thing that everybody looks at. Not always as easy as just looking at what a salary or what a pay is going to be, especially if you're on the employer side. You have a lot of, you won't deal with these issues as much on the employee side, making sure your agreements are compliant. But on the employer side, there's a lot of compliance issues to make sure that what you're doing is actually permissible under the relevant law. If you're an employee, mostly you're going to be focused on, how are you going to be paid? And that can be through a salary, it could be through some type of performance-based or production-based. It could be bonuses that are based on specific criteria or bonuses that are discretionary. And it can also be from ownership, potentially, of a practice at some point. And Mike mentioned earlier, if you're going to be in a situation where you're an employee and you're also a shareholder or a member or a partner of a particular practice, what happens if somebody ceases to be employed? Are they still going to be able to collect revenue off of the practice, even though they don't have to show up every day for work? And usually we will write our agreements with respect to the ownership agreements so that there's essentially an obligation to sell that interest, so you don't have that situation. The people who are actually doing the work on the ground get the benefits of it. Anything Mike or Brian, on the comp?
Stark Law. And you have to be very careful of payment for ancillary services. If you have an MRI, if you have an X-ray, if you have a lab, DME, there's a whole host of things in the 11 enumerated categories of designated health services. And you also have to be careful with it on the Florida Patient Self-Referral Act side. These are very complex, very detailed analysis, well beyond what we can cover in an hour today. But the biggest thing we see come up is the way that bonuses are paid across a group practice for ancillary services or supervision of mid-levels, ARNPs, PAs, nurse midwives, etc. Always make sure that before you sign on a dotted line for a performance bonus-based contract, that if there's an ancillary component, it's been evaluated, because there are very strict ways in which you can share those under the Stark Law. You have to be a group practice. It's usually only for personally performed services or directly supervised. If you're going to have a pool of ancillaries beyond that, they have to be split up in a way or divided up in a way that is not related to the volume or value of referrals. Otherwise, you could violate your in-office ancillary services exception if you're traveling under the Stark Law, etc. Just make a note for today that if you're in a complex compensation formula, especially in super groups or hospital settings, you have it reviewed by counsel, healthcare,
Exactly.
experienced counsel like our firm. So
yeah, especially if you're establishing, if you're putting together something like this, you really need to be guided by counsel through these. It's much more complex than something we can cover in a few minutes.
Going to the actual methods of compensation, I'd say one thing that you don't want ambiguity about in the agreements is the time frames. If you're getting some sort of performance bonus or productivity bonus, you want to know exactly what periods that works under. Is it calendar quarters? Is it quarters calculated from the date you began working or the execution date of the agreement? And they're all good options. You just want to make sure there's an understanding between the parties as to precisely how it'll work. The same goes for when a doctor is leaving and the employment agreement's being terminated. Is the doctor entitled to compensation for all services billed up to the date of termination, or is there some sort of cutoff for fees that haven't been collected within 180 days after the termination? Again, there's multiple options. Most of them are fine. You just want to make sure that both parties have a clear understanding and agreement on what those timeframes would be.
Yeah, it's a great point. And again, the time to make sure you have this well established is when you're entering into the relationship. It's probably going to be one of the times when you have the greatest bargaining power. If you are the employee, keep in mind there's a reason you're sitting in the position you are, and you have an opportunity to clarify things and push for the specific points that are important to you. And we talked a little bit about discretion. Besides monetary compensation, we have other benefits such as insurance, and malpractice insurance could probably be its own topic. Mike and Brian do litigate malpractice claims. The big distinction is understanding whether or not your malpractice coverage is an occurrence-based or occurrence-based or a claims-made policy, and that's different, and one is going to require that you have tail coverage from year to year, so that the difference is essentially that on an occurrence-based, anything that happens during a particular year gets covered. On a claims-made, it's only things that happen in that year, and when you have a claim that's actually made in that year that gets covered. So you need to make sure you have the appropriate rider for that. Anything?
It's great advice. I don't know how many times we've had to have, when Brian and I, before we joined the firm this year, we'd call Eric and say, you need to take a look at this as personal counsel for this client. Now we just send it over as long as we don't have a conflict of interest in looking at it. But here's the thing, you need to understand an occurrence versus a claims made. One of the key, I forgot this earlier, one of the key things, differences between a hospital-based and a private practice-based employment agreement is often the hospitals will have an occurrence-based policy, but you need to make sure you're under that. A lot of hospitals now, with the growth of their groups, have had to become flexible and not only putting them under their own self-insured trust or occurrence policies, but also some employed physicians can't qualify for their underwriting criteria. So they put them into, they contract for or buy policies from private carriers, the ones that we see all the time out there that are very reputable carriers in the marketplace. But the difference is those are claims made, which require, if you want coverage when you leave, tail or at least an extended reporting endorsement, and they are different, those two things, or versus an occurrence. One quick thing on tail, it's permanent. If you buy it, it's there, it's in place for a defined amount of time, most times into perpetuity, although perpetuity is often a fun term under Florida law, but an extended reporting endorsement can be different, and that can mean that the entity or person can get a retroactive date and you're covered. They can go out, maybe if an employee leaves, and buy a policy from the same carrier or even a different one now, and add themselves to it and get a retro date back to the start of their employment with their soon-to-be former employer. The problem is if they let that policy lapse, the insurance carrier goes out of business. We see that occasionally here in Florida in malpractice crisis, or they just decide to go bare and terminate the policy. There's no more coverage. So there is a big difference in tail versus an extended reporting or retroactive date. I can tell you that our retainers for bare physicians that want to defend med mal cases are very steep, because usually when a plaintiff knows and the plaintiff's counsel knows you're bare, they're going to come after you harder to make you try to settle. They're going to litigate harder than if there's a carrier out there. Different deep pocket, shall we say. So be very cognizant of those facts. Yeah.
Great points. Other benefits, I read somewhere recently that employee benefits can in some circumstances be up to 20% of the compensation for an employee. Now, you know, your more highly compensated employees, that may not be exactly the case, but some of these family insurance plans, disability insurance can be incredibly expensive. So if you can get that wrapped in, it could be a nice perk. Retirement plans, reimbursement for CME expense. If you have a particular practice that it's difficult to get quality education, continuing ed for, you may need to travel for it. This may be an area where, for instance, you know, a practice won't budge on vacation, but you can finagle some extra time out for traveling for CME, and you can, you know, oftentimes if it's anything like legal, they have those education events and some fun places where it's nice to get away to once in a while. So it's a little creative thought, and you're negotiating.
People often ask us what's the standard for vacation or CME time off. It depends on the medical specialty and the type of employer, but for a newer physician, you generally see 2 weeks, 10 business days, paid days off for vacation, and 1 for CME. If you're either side of the fence, if you have a physician coming in that's board eligible and needs to become board certified, and they have to obtain a very large amount of CME to get that, and they're in a much higher end specialty, that's a point, going back to what Eric said before, that's a point that needs to be negotiated up front. Who's going to pay for what? The employer's hiring this doctor on the expectation to become board certified. The employee doesn't want to throw out 10 or 15 grand over a couple of years to travel and go to these courses out of their own pocket. I'm not a tax guy. Eric has pretty good experience, and certainly lawyers in our firm do, but what's deductible? Who pays what? So very key points. And then on the retirement planning side, always know what you're getting into on both sides. Just a tidbit, when we started our own firm years ago, before we merged with Forster, Boughman, Lefkowitz, and Lowe, these guys set up our plan for us, and it was very well done, but it was a very lucrative plan for all of us. But that adds to the cost, and it adds to the benefit. And if you have that, your employees and your employers need to know, and you need very competent non-healthcare but tax and benefits counsel like the folks here to do that. So.
Term of the agreement. So you have your, you're generally going to know when you're starting. Really what I think is the important thing to understand is the termination, how the agreement can be terminated. And since I know Brian just dealt with this issue, Mike alluded to it earlier, on the for cause and not for cause termination. Brian, do you want to cover the distinctions there and some important points to be aware of?
Sure. And like Eric mentioned, the terms of the agreement, the commencement date, the initial term, make sure you understand what those mean. One way a contract can terminate is automatically. If there are no extension terms in the contract and the contract sets out that it's a 2-year agreement, if there's nothing in the contract explaining what happens at the end of those 2 years, there's potential for misunderstanding. What a lot of contracts will do is set out that the first year or first calendar year is the initial term, and unless either party advises the other 30 days prior to the end of the initial term, 60 days prior to the initial term, something like that, in writing that they're planning to allow the contract to terminate, or that they are terminating the contract, or essentially choosing not to renew, then the contract renews itself. So you'd have the initial term, and then you'd have the extension term. Extension terms could be typically for a year with the same kind of auto renewal provisions. Beyond that, there's termination for cause and termination without cause. There's a lot of ways you can have termination. The business could cease operations. The physician could become deceased or permanently disabled. There could be a mutual agreement to walk away from the agreement to terminate the relationship. Or you can have the one that most contracts devote the most text to, and that is termination for cause. You can have an option in there for the physician to terminate for cause and for the entity to terminate for cause. And what's typically in there is some sort of list of what are appropriate means to terminate for cause. For termination without cause, typically you're only going to ask for some sort of written notice. If you're going to leave, give us 60 days, let us know, and during the course of those 60 days, the physician's typically expected to continue in their duties and responsibilities. You'll want to have provisions in there on both sides for assisting with a smooth transition to make sure there are no interruptions to patient care, anything like that. And if you're the entity, you may have provisions in there specifying that if there's an agreement to termination without cause and the 60-day notice has been given by the physician, do you have the ability to accelerate that without penalty? as far as termination for cause, there are, it's kind of sky's the limit. You want to put in things such as if the physician, if anything happens to the physician's license, if the physician is charged with any sort of crime of moral turpitude, or anything that would lead you to believe that their ability to practice medicine or in their field is impaired, or potentially puts patient at risk. You want to have carve-outs for that sort of thing. Like we discussed earlier, you're going to want to have carve-outs for if the physician commits any sort of violation of the policies or procedures of the entity. And as well, if this would be the sort of thing included in policies and procedures, but if the physician becomes addicted to a substance or to alcohol that impairs their ability to practice medicine, you'd want to have a carve out for that as well.
Talk about, Brian, real quick, you talked about the automatic renewal or evergreen renewal. We see those, they renew, unless otherwise terminated, but what if there's no renewal provision? How would you go about extending it? I'm talking about amendment provisions. This is often something we see that isn't done well. It's done on a handshake or a wink and a nod, yet the agreement will say it has to be amended another way.
Right. Any of these contracts should have a provision in there saying that any amendment, modification, or change to the agreement can only be done in writing and executed by both parties. If there's no sort of auto renewal for the contract and it is going to terminate, and you really just, you're both on the same page, you both want to just continue under the same terms, you have to put it in writing. You have to have it signed by both parties, and you want to have that understanding memorialized, because a handshake works when both sides are in agreement, but you don't know where you're going to be 8 months from then.
And so when you have an agreement that terminates on its terms and the parties continue to work for each other, what do you have? Basically an at-will relationship then?
It would be at will.
And
explain to what that means, though. To us,
Sure,
that's a
yeah,
very,
that's
so we're all nodding our heads, but Brian, what does an at-will mean at that point? Are you under the same terms and conditions of the contract, or you've seen this issue come up in cases before?
And it can be unclear. You might be able to convince the court that in the absence of any sort of renewal, but with the understanding that the parties were continuing, the courts often will say, okay, well, it's assumed and it seems like the understanding between the parties was that the terms will continue to govern from the agreement in the extension of the relationship, despite there not being any instrument memorializing that. But the court may not necessarily extend that to things like restrictive covenants. If a contract says that restrictive covenants are valid from 2 years after the termination of the agreement, and the agreement ends, but the parties continue on in an at-will relationship, it's unclear under the contract, in most cases, whether or not the restrictive covenants would survive and continue and not toll until the doctor ceases working for the entity. Because under the terms of the agreement, it most likely says that the restrictive covenants begin the 2-year countdown at the termination of the agreement rather than the relationship. That's one of the reasons it's important, if you're going to amend, if you're going to renew, to have all of these terms clear, because courts are going to look at whether it was clear from the 4 corners of the document within the text of the agreement, whether both parties understood when the restrictive covenants would kick in and when they would end.
excellent points. And with the for cause provision, one thing you want to see there, in most circumstances, you're going to want to see that there's also a written notice. Now, some things, if you lose your license, if there's a health, safety, welfare, integrity issue, then the termination might be more appropriate as immediate termination. But for some circumstances, such as disability, for some reason you're not able to meet the duties on a temporary basis, or for some reason you are not complying with some technical rules or incorporated policies of the practice, you want to have notice of that. So you want written notice and an opportunity to cure. So if it's something that in 30 days you can fix, and with that, even if you have something that I normally will change if I'm marking up an agreement for somebody who's dealing with that, is I'll want an opportunity to cure or to commence the cure. So you may have a situation where you're involved, maybe it's a moonlighting gig and you didn't realize it was violating the agreement because it's a charitable, or there's you thought it was an exception, and it's going to take you 45 days to get out of it. Well, if you have an opportunity to commence the cure and it's something that you can unwind during that time, if you're performing the diligent steps, if you're performing the steps diligently that are necessary to cure, then there's a chance that you can actually remedy that. And more preferable, I think let me know if you guys disagree, but in most circumstances, to avoid even the chance of litigation, we'd rather have folks terminate without cause. And most agreements, even if you have something that looks like a 2-year or 3-year agreement or a 5-year agreement, that agreement's still probably going to have a termination without cause provision in there that says, Brian said, going to have some kind of notice provision. And then anything you would add to that? Or?
No, I just think you made a great point, Eric. We obviously, as a full service firm in this area, can litigate. We dissuade it. So if you're not taking one key point that we're all hammering on is away from this, please do. Take care of this stuff up front. It's a lot easier to negotiate it up front. You can't get everything in a contract, but you can certainly identify these issues and try to agree to them. You know, we have a kind of a fun saying, and I like to quote it, you know, with litigation, the only people who make money out of it are lawyers, and that's 50% of the time. So it's expensive and stressful. So listen to what we're telling you, and particularly Brian and Eric today with regard to this. Take it up, try to avoid litigation if you can. If you have to, you have to, but try to take these points and hammer them home up front.
Another one of our little things that we say internally or tell new clients is that yes, sometimes it can seem like a cost that you don't want to spend to hire a lawyer to look at one of these things, but we've got qualified people here, and there are other qualified people out there, and in most circumstances it's much less expensive and less stressful to hire a lawyer on the front side than on the back side and deal with litigation.
Absolutely. What's that saying? A person knows himself for a client as a fool. How's that go?
Yeah, the lawyer that has himself as a client as a fool.
Yes.
And
yes.
Yeah, get somebody to take a look at this. It's not that outrageous to have somebody go through it. At least you know what you're looking at if you do walk away from the practice.
Yeah, oftentimes making sure that the right clause is in there that will avoid disagreement later is an ounce of prevention to avoid the pound of cure.
So we've got just a few minutes left, and there's a couple points that we'd love to hit, but and again, if you have any questions, pop them up here and we'll address those. Probably something that we get questioned on a lot, and something that's heavily litigated here, especially in Florida, and I think it's in a weird state throughout the country, are non-competes.
Yeah.
So maybe a couple minutes on non-competes, and I know Mike and Brian have both done a lot of work in this area. What's most important for the folks to look out for in a non-compete agreement?
So I'll preface it, but then I want Brian to pick this up. You know, with physicians, the law has changed significantly over the last decade after the Sinal and Tamala decisions. It used to be that if you had a restricted area and you set up within it, that was going to be very difficult to get around if you were the employee, and very easy to enforce if you were an employer. With Sinal and Tamala, in a nutshell, what they said is, you may have a restricted area, but what's the key here? What is the protected, legitimate business interest? And in both those cases, you had doctors who stayed within their defined restricted geographic area, but took very, very cautious steps to not see patients that they had treated at their prior practice or could have treated, or that their prior practice treated. And the court said that's fine, and they let them do it even though referral sources could find them. In a nutshell, on those, what courts said back in those cases was future streams of patient referrals aren't necessarily legitimate protected business interest. Now, last year, the Florida Supreme Court took cert, and Brian will explain what that means, on a set of conflicting cases, one here in the 5th District Court of Appeals, where we're in Central Florida, and one out of the 4th District Court of Appeals. And there's a question now whether Tamala and Sanal still read the same way or apply the same way, even though neither one of those agreements or cases involved physicians. So I think Brian needs to pick it up from there and explain that we're back in a bit of a gray area about how enforceable they are. And with that, not only do you have to look at a non-compete, but you have to look at what the non-solicitation says. And they have to be separately written but integrated covenants. Brian?
Now, following Sanal and Tamala, we were in a place of some certainty. The court had established that these future streams of patients, or as you might call them, referral sources, are not the kinds of things that could be protected under a non-compete or a non-solicitation. More recently, like Mike mentioned, the 4th DCA and 5th DCA had a certified question of law and a conflict of law between them based on Americare and Medicis cases. These were appealed up to the Supreme Court, which recently took a look at both and ruled that, well, overturning Tamala and Sanal to a degree, they said, we're not going to say that referral sources and future streams of patients are automatically not protected under a non-compete. They can be a legitimate business interest that would fall under a non-solicitation or a non-compete provision and may be protected by a restricted covenant. It would be on a case-by-case basis. So like Mike said, we're back to a gray area and it's a little more uncertain now. So when crafting non-solicitations and non-compete provisions, you're going to want to make sure that it's clear, in some cases possibly even putting in the specific names of what this physician understands you consider to be a legitimate business interest. Things like trade secrets are automatically legitimate business interests. You obviously have a reason to be protecting it if it's treated as a trade secret and confidential. Things like referral sources, you'll want to take a little extra care to include and incorporate into these restrictive covenants so that a court later will find them enforceable.
And two key points on that. On the non-solicitation side, we like to joke around, but we're serious when we talk with clients that the internet is the great equalizer there. Under Florida law, if you leave, and non-solicitation means you're not going to take your patient list with you if there's a non-solicitation provision, and send them an email and a letter and a nice photo ad, but you can put your name up on the internet with a little Google search. They can find a new practice. That cannot be restricted. So the question becomes, if you do that, can you set up in the restricted area? These are very, as Brian's saying, very fact specific. All three of us have litigated a lot of this. We talk about them, we litigate together for our clients all the time, and they're very fact sensitive. So be cognizant of that non-solicitation, that as an employer and employer, just necessarily having non-solicitation doesn't stop somebody from being able to advertise on the internet to a general public. One thing we did not mention earlier, but we definitely have in here, and that's medical records. If the agreement, under Florida law, 456.057, the person who creates, the provider professional who creates the record owns them, unless you have a written agreement. And it doesn't say it in the statute, but of course have read the written agreement into it that says your employer does. If you're an employer, you need to have that in there. We can't tell you how many times we have gone up against opposing counsel and they don't realize when our client takes the records, they can't because that's not in there. The agreement needs to clearly state that the employer owns and that the records and it remain the property. That's that non-disclosure. And that's a great way to stop somebody from hijacking your patient records in the middle of the night and your practice.
Yeah, on the, and we're about at 1 o'clock, so we appreciate you joining us. We didn't cover everything that we had listed today, but you go through the slides, and again, if you
Eric, let's open it up for questions, if that's okay.
Yeah, sure.
Maybe I can unmute everyone.
Tamala is Tummula.
And
A-L-A, Tamala. Tummala. It's a 5th District Court and a Florida Supreme Court case. There's two separate decisions.
right. And then the other one was
Sanal is S-A-N-A-L. It's also a 5th DCA case. I believe the Florida Supreme's just affirmed it. There was no written opinion on it. Yeah. And that's out of Jacksonville area. So.
And we can,
05 case.
if you email me, the person who asked that question, if you go ahead and email me, I can send you the sites for that case. I have them written down somewhere. Yeah. Any other questions?
We've unmuted everyone, so if you have any questions, you can call them out.
All right, going once, twice. Maybe that means we covered everything people had questions about.
We were clear.
And
Unambiguous.
if you think of anything afterwards, oh, wait a minute, I've got another one that popped up here. Somebody typed one in. Oh, it's a long question.
So let me read the question for you. You had mentioned briefly asking one of your attorneys to be personal counsel. Is that when you don't represent the physician insured?
Actually, it's a great question, and we'll probably all touch upon this. Personal counsel has a lot of meanings, but if you are, say, looking at an employment agreement, your counsel is your counsel. But if you're in a situation where you might need a coverage opinion, you're looking at a med mal claim, a potential claim, you may need separate counsel from your insurance defense counsel. And what we mean by personal counsel is if there is something in the case that might cause an issue with coverage, defense, or a potential excess of limits, and I'll let Eric explain what that means, what I'm using in a legal parlance, you would want to hire your own counsel, because while defense counsel has a duty to both the insured and the insurer, they can't put themselves in the middle of that. The carriers that we work for are very good. We have several we do it for. It's a very small set of carriers, but they're very good at when we say we need to get our client, if we're defending in personal counsel, and that's when we pick up the phone. To delineate that, a lot of times we're just looking at policies as coverage counsel. We can be coverage counsel in a non-med mal case, and we often look at it, but we always get Eric involved in that because he has a background in insurance coverage. So Eric, on the excess, please pick that up. And
yeah, so you will have your policy. It may say you've got, $1 million in coverage, and if you're in a situation where you're being sued and there may be liability that extends beyond the policy limits, that's a situation where you may want to have your own attorney, and that's your personal counsel who's advising you separate from insurance counsel. The insurance counsel has been hired by the insurance company. They're being paid by the insurance company, and they will litigate. And as Mike said, we haven't had issues where it's not a matter of the insurance company or the attorney isn't doing what they're supposed to be doing, but the duties are different. And if I'm representing an individual and I see a situation where a case can be resolved within policy limits, but the insurance company is not making that happen, and I think that my client that I have duties directly to has some potential exposure, then I have a duty to raise that with the insurance company and try and put some pressure on them to make sure that my client doesn't have exposure. And that brings up a broader point that I think is also very important, since we've got 3 attorneys talking here, is whenever you're in a situation where there's multiple parties involved, and that could be you're going to go into a practice and partner up with somebody else, and there's you and your partner and an LLC that you're going to create. Understand who's represented by whom. So one attorney cannot represent a deal. You can't represent a transaction. So, and we will put in our
and the owners.
Right, you can't represent, you have to owe a duty to somebody. So you'll have folks that, and I've heard it from attorneys that'll say, well, I just represent the transaction. Can't happen. You have to figure out who you represent. If it's the company, then that's who you owe duties to. If it's individuals, that's who you owe duties to. Now, it doesn't mean that you can't, you provide some general advice and that you always need to get a different attorney for every party. And I will tell you that attorneys struggle with this. And sometimes there's multiple players involved. And one of the questions we have to stop and be very careful of is, who is our client and to whom do we owe duties? And so, coming back to the insurance issue, you've got a little bit of a, just naturally there was a little bit of a push-pull there when you have an insurance company that's insuring up to certain limits and they're being paid to represent a doctor, but the doctor has his own individual agenda and wants to make sure that he's got full coverage.
And those are things to think about up front when you're looking at it. If you have coverage under your employment agreement, who's the carrier? What are the limits? What are the agreed to? Does your attorney who's reviewing it, either side, the employee know that carrier? Do they have experience with it and how those are going to be handled if claims come up? On the deal side that Eric brought up, going back to an ownership situation, if you're becoming an employed physician and owning, those are very key points. A lot of times we'll see folks that'll come to us and say, well, the attorney for the group told me that you know, they're also my counsel. And that's not all, you rarely hear that, but what happens is the employed physician who's buying in thinks that that attorney is their counsel, even though the buy-in documents will say you've had the opportunity to retain and consult with your own counsel. And that's, to go to Eric's point earlier, you know, and Brian's point, spend a little money up front to avoid spending a lot and a lot of stress on the backside.
And there's a follow-up question here, and somebody asked if we provide coverage counsel and individual counsel. And what Mike alluded to earlier is, prior to us joining forces, which has enabled us to do a lot more things as one firm. Mike and Brian, they were in their own practice, and we were in a separate practice. And before this firm, I was at a different firm. And so for years, we've worked together. So when we were in separate firms, there were situations where I might provide personal counsel and Mike would provide counsel provided by the insurance company. We would not do that now. We would have a conflict situation. I can't imagine that would be.
But only for the same carriers that we.
For this, right. We wouldn't,
yeah.
in a case where the carrier is now hiring us, because they hire the firm, they hire the lawyer, but they hire the firm to provide counsel. We would recommend in those situations that insured consider going and hiring his separate personal counsel if there was any questions where there's a potential conflict that always arises in that situation.
There are still a lot of situations, though, where we are not panel counsel or don't accept cases from a particular carrier, whether it's a med mal carrier, cyber liability carrier, or whatever, where we can be coverage and personal counsel. So it just, key question there that Eric hit on, a key consideration, always ask, always talk to the attorney about, does your firm work for a particular set of carriers? And if they don't, you can definitely do the coverage work. Sorry.
No, yeah, the great points. Conflict, you know, we have a Florida bar hotline, and this is, again, something that the attorneys, I think, struggle with themselves. So it's really a case-by-case situation. We have conflicts of interest, some that are waivable, some that aren't waivable, and some that people just don't pick up on.
Hey, thank you so much, everyone. Have a wonderful afternoon.